Okay. We are starting with the class now, and well, yesterday just wish to make one addition that we have discussed in the yesterday's class, that the about the syllabus. So would like to share the syllabus with you. That one thing which I have mentioned there about the Special Contract Act. So there is a slight change this year. So the marks weightage for the Special Contract Act is for 9 marks, and there is one question, half question is from that section only. So I would like to share that particular screen again, otherwise I can discuss with you the fresh. Yeah. So as requested, so just it will take just 5 minutes before we start with the contract act. So when we talk about the structure, we have already discussed that this is 75 marks thing, and 25 marks would be the internal marks, right? So internal explanation I have already given to you. When we talk about Indian Contract Act, in Indian Contract Act we have Journal Contract Act, where we have all the basic requirements. So there is the 1.5 question is here, and then there are these special contracts, and within these special contracts we have indemnity and guarantee, and we have bailment and pledge, and we have contract of agency. So in out of these three special acts, there is a half question weightage is being given. So two questions will be there from the Indian Contract Act, and the weightage will be 22.5 and 7.5 mark question. So 30 marks would be weightage would be given to the Contract Act. Then remaining things are same. Sale of Goods Act, one question for 15 marks. Then LLP, one question for 15 marks. And then your Indian Information Technology Act, and again 15 mark question. So one question here, one here, one here, and two question here. So five question in total, and the calculation, etc., other things we have already discussed. So now we are starting with the Indian Contract Act, and the weightage of the Indian Contract Act is more than 30 marks, because when we talk about your internal exams or assignments, so generally the first units are being covered. So in if we say that there are 20 marks assignment or 20 marks, we can say the weightage is being given to your internal assessment. So in that case, this 20 marks weightage also is divided into these two only, because by the time we have to conduct that, so these two sections will be able to cover. So this 20 marks is going in addition to this 30 marks. So it means the weightage of Contract Act nearly comes 50% of your syllabus. So we'll go a little slow with the particular section so that you understand the things well. And when we talk about the structure, so yesterday also I have told you that there are the provisions. The provisions are given in the act. These are given in the form of the rules, which we have to remember. Then there are certain case studies which support certain provisions and the sections. So we have to discuss these case studies, and these are generally considered as the practical questions as well. So you will be receiving minimum two practical problems in the exam. And other than that, you can use these case studies as examples to support your provisions and support your concepts. So other than case studies, there comes the examples, wherein you do not require to remember the name of the parties or name of the things. So there these examples can be the created, or these are can be the hypothetical example, but you can use the example to explain your concepts. When we talk about the sections, or we talk about the definitions, so when we talk about sections, we need to remember at least important sections which will be there. So it will be an add-on benefit. But if you do not remember the section, so it is advisable that you do not write the wrong section. When we talk about the definitions, so if you write the definition and you put the inverted commas, then it needs to be as it is. But if you are not good in mugging up and remembering as it is, so just avoid these inverted commas. So you just can write down the definition this way, and you can if there is certain word is here and there but the meaning does not change, the definition is acceptable. When we talk about the explanations, so explanations can be in your own language, but in the law paper, this is very, you need to be little careful while giving the explanation. It should not change the meaning, because one word using yes or no or not will change the meaning of the concept totally. So it should not affect the meaning of the concept. So that is very, very important. So for that thing, you need to remember. And one more thing would like to add here is that whenever we are writing the university exam, so the length of the answer is important. So it will go according to the QQP principle, where we talk about the quantity, and quantity is direct proportion to the weightage of marks. So whatever weightage of marks is given, the length of the answer should be in proportion to that. So if for this thing, for long answers, you need to practice before your exams. And when we talk about the quality, so quality is definitely prime important, or the central idea. So we can say that whatever item or whatever concept is being asked, that particular concept needs to be explained, no here and there, or the stories etc are expected. Then the third thing is the presentation, that how you present your answer, that is also going to affect your marks. So if we target our marks, so in this particular case, if we follow these instructions, we can get the things well. And with respect to the your course structure and other things, I will be sharing your syllabus copy and the details which we need to follow, instructions etc on the classroom itself, right? So now let's begin with the topic. When we talk about the Indian Contract Act, then in that particular situation, my screen is presentation is visible to all of you.
Yes, ma'am.
Okay,
Yes,
and it
Yes.
in a
Yes,
slideshow
ma'am.
format.
ma'am. Yes, ma'am.
Yes.
Okay. Okay, so let's start
Yes,
with
ma'am.
the first concept, that is meaning of contract. When we talk about meaning of contract says that it is an exchange of promises by two or more person, resulting in an obligation to do or not to do an act, the obligation which is recognized and enforced by law, and gives corresponding right and duty to the other party. So in this particular case, when we talk about the meaning of contract, so meaning of contract says that there is requirement of a promise between two or more person. So when we talk about the meaning of contract, the definition or the explanation says that there is the requirement of a promise, and this promise needs to be in between two or more persons, and it needs to give rise to an obligation which is recognized by law. So we generally call it as the legal obligation. And it also gives rise to corresponding rights and duties. So in this particular case, we have to understand this particular definition. And then when we will move further, so we use the term, the contract is an agreement enforceable by law. So we generally use the term the contract definition by the law. It is given under section 2 that contract is an agreement enforceable by law. So when we talk about an agreement, the definition of agreement says an agreement is a promise and every set of promises forming consideration for each other. So to an agreement, to be a contract, we require that agreement need to be between persons two or more persons. So that promise needs to be there. It should exist in a form of a promise, and this promise must give rise to the legal obligation. So for an agreement to become the contract, enforceability by law is required. But which agreement will become the contract? So it should carry all these four essentials. So there is one essential, consensus ad idem, which we'll discuss in this class itself. So one thing, plurality of person is needed. Another thing, there needs to be a promise. When we talk about the promise, this promise can be to do or not to do something, right? So it means it can be in any nature. So when we talk about the General Contract Act, so General Contract Act is talking about that the subject matter can be anything. So when we talk about the subject matter is the reason or the central idea for which we are entering into the contract, right? So it means कि हमारा पर्पस क्या है, किस पर्पस के लिए हम कॉन्ट्रैक्ट में आ रहे हैं, who is going to decide this? The parties to the contract will decide. So if there is a promise between A and B, so what to be performed, how to be performed, when to be performed, what will be the consideration, what will be the specifications of contract, and other terms of performance, etc. Everything would be decided by the parties to the contract. So here we say that when we talk about the contract says, the definition says, contract is an agreement enforceable by agreement. Contract is an agreement enforceable by law. So it means that the agreement needs to be enforceable by law, where we have nearly 1 to 10 conditions which needs to be fulfilled, and these conditions are given under section 10. So we'll be discussing. But when we talk about the meaning of agreement, so meaning of agreement, definition of agreement says that every promise or every set of promise forming consideration for each other is an agreement. And in that particular case, for an agreement to be a contract, it needs to satisfy these basic conditions. These are the rules, these are the provisions. So there needs to be 2 or more persons. So it means if one person is promising to oneself, it cannot be considered as an agreement. If there is no promise or there is no subject matter, whatever is the subject matter, it is immaterial. But that there should be something that should be done or that should not be done. Then we talk about the legal obligation. It means that the parties must have the intention to do it legally. They are not just bluffing or kidding or promising just for promising sake. So this must give rise to the legal obligation, and there must be consensus ad idem. Consensus ad idem means that whenever they are entering into the promise, they are understanding the terms of the contract or the subject matter in the same sense. So they are not talking about the different things at the time of making the promise. So one by one, we will be discussing all these aspects. And in enforceability by law, all the terms, etc., we will be discussing which are required. So the agreement plus enforceability by law will form a contract. So when we say meaning of contract, it is said a contract is an exchange of promises by two or more person, resulting in an obligation to do or not to do an act, which obligation is recognized and enforced by law. Every contract gives a right to one person and cast corresponding duty on the other. So this is the meaning. And if we talk about the definition of settlement, I'll discuss later. Now, if we talk about Indian Contract Act, Section 2, subsection H defines a contract is an agreement enforceable by law. By author Pollock, it is being defined every agreement and promises enforceable at law is a contract. So it means that we need to understand the definition of agreement. We need to understand what are the conditions required for the enforceability by law. So one definition you can remember by section 2H, and the one journal definition you can mention. Now, when we talk about the agreement and enforceability by law, so agreement is being defined under section 2, subsection E, which says every promise and every set of promises forming consideration for each other is an agreement. Then we have, when we move further, so we say that what do we understand by a promise? Promise definition as per section 2, subsection B says, when a person to whom the proposal is being made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So it means that there must be a proposal. The proposal must be given to the other person. The other person must give yes to that particular proposal. And when this particular process happens, this exists in form of a promise. And when promise is supported by consideration, it becomes an agreement. When agreement is enforceable by law, it becomes a contract. So it says that an agreement is an accepted proposal, and to form an agreement, there must be an offer by one party and acceptance by the other. So we can say that agreement is offer plus acceptance plus other conditions which are required. So here it is being given that proposal is a promise, promise resulting into the consideration, added by consideration results into the agreement. Agreement might be legally enforceable, might not be legally enforceable. So for that reason, we need to understand the concepts. It means that when we talk about an agreement, when we talk about an agreement, so an agreement is promise plus consideration. So consideration means, consideration word comes from corresponding duties and obligation. If one party is doing something, other party is not doing something in return, so it means there is no consideration. And when we talk about the promise, so promise means that the person has made an offer and the other person has given the acceptance, right? So it means that when we talk about an agreement, so it must emerge as offer and acceptance. It will result into the promise, and there is consideration. But this particular agreement can be enforceable by law, or there is an option that it is not enforceable by law, right? So when we talk about enforceable by law, so enforceable by law means that it is combined with the essential elements under section 10, and all the essential elements or all the required by law for the enforceability thing are being satisfied. And if there is an agreement, there is a promise, but if it does not, satisfy any of the conditions under section 10, then it will not be enforceable by law. So very first example here we can take is, give me a second. Yeah, what happened? So where were we? We were that it is not enforceable by law. So one very example we can take is, I think it has gone very big. So when we talk about the not enforceable by law, so we say that there is an agreement, and this agreement is here. Here is a promise that can be there. There can be offer and acceptance, right? And there must be some consideration as well, but this consideration is not legally recognized by law. In this case, we can take an example that, for example, A has offered to B to go out for dinner, right? In this case, A has offered B for going out for a dinner or for a movie. So in this case, A has made an offer, B has accepted, and something is there. But in this particular case, there is no legal obligation, right? It means that there was no intention to have any legal relationship, or there is no legal binding in this particular case. So until unless the particular thing is being recognized by law, or that obligation gives rise to legal binding, it cannot turn into the contract. It will remain agreement, because for an agreement we need offer and acceptance, right? But in that case, there is a promise, but this promise is, might be, the consideration might be in return of some satisfaction, right? Or some other emotional needs. But in that case, this is not recognized. So even if in the your business organization and management, or in the economics, you have studied the concept of non-economic activities. So in that case, non-economic activities does not give rise to any of the economic benefit or any mode of return. So in that case, all those activities where there is no intention to have legal binding or legal relationship will not emerge into the contract. So for an agreement to be a contract, the agreement must be enforceable by law. And the very first condition of enforceability by law is intention to create legal relationship, right? So on this basis, we can, classify the agreements into social agreements and into legal agreements, right? So there can be the example of social agreements in form of, for example, father promised the son, okay, you have got a very good score in the 12th standard, so let me get I-12 for you. And somehow, due to the pandemic or due to some financial constraints, he is not able to fulfill his promise. So in that case, son cannot go to court of law. We will discuss the doubts at the end of the session. If the father refuses the son that I cannot get it now, and the son is annoyed, he cannot go to court of law for the performance of the contract and that the promise is not being fulfilled. So in that case, you can go to court of law. It depends that whether that particular promise, when this particular promise is made, whether it has resulted into a contract or not. So here is a journey for the same, that this particular promise must be supported by legal obligation. It must have all the essentials for the enforceability by law. So, in that particular case, we have to understand that agreement can be divided into social agreement and into legal agreement. Legal agreement will turn into the contract, social agreements will not turn into the contract. So, all the agreements or all the promises which are being made without having any intention to have legal relationship will be turned into will be considered as social agreements. All the obligations which are for the social needs or non-economic needs will not give rise to the contract. So in this particular situation, the social agreements are not enforceable by law, and the it will not depend on the nature of the activity. It will depend upon the intention with which the particular activity is performed. So for example, if a mother is taking care of the elderly people at home, so it is a non economic activity. The promise is not binding. At one point in time, if she is not able to fulfill the requirement, so she is not legally bound to do. She is bound to do only on the basis of the emotional and the social needs. But if you have hired a nurse to take care of the elderly people in the family, and in that particular scenario, if the nurse is not able to fulfill her duty, then in that particular case, you will refuse to make the payment. And once you will refuse to make the payment, so it means that it is in as a return that she has not fulfilled her duties. Similarly, if mother has cooked the food and you have not liked the food and you are annoyed, so maximum you can show your emotional tantrums that I am not going to have food today. But if you have ordered the food from outside and that particular food is not as per the requirement or does not fulfill certain conditions, so you can return back that food, you can claim back your money. So that legal promise is being fulfilled, that yes, this particular thing is being served, it is having of this quality, it is not harmful for any human consumption. There are so many requirements. So once the particular transaction or particular activity is done with the intention to have legal relationship, it has some offer and acceptance. For example, you have ordered a food and there was some discount coupon was applicable, you have applied that, and then this particular discount was not activated on the particular transaction. So you have the helpline numbers, you will call and you will ask for the compensation or for that adjustment. You want to recharge your phone, you want to put up some package or some money for the calling in your phone, so you just click on the app, your payment gets debited, but the amount is not being credited or package is not being activated in your phone. You can call and you can claim the money back. You have ordered certain goods physically, you have purchased certain goods, or you have ordered online. If the particular goods does not turn out to be fit or you do not receive, but your payment has already been debited, you can claim back your money. So it means that the performance is compulsory. Once we enter into the contract, so in that particular situation, we are bound to perform that contract. Let me come to the slide. Now I would like to go to the earlier slide which I missed. Yes. Now we can discuss the slide where it is being explained. The law of contract is not to be whole law of agreements, and nor is it the law of obligations. So it means that there can be agreements. Agreement is a wider term, which can be that there can be social agreements, there can be legal agreements, and nor is it the whole law of obligations. Obligations can be social obligations or can be legal obligations. So law of contract talks about only those agreements or only those obligations which are recognized by law, which are legally enforceable. So it means it is the law of those agreements which create obligations and those obligations which have their source in agreement. So it means that both the things are required. We require the obligations, we require the agreement, we require the obligations to be recognized by law. So only those obligations which are recognized by law, which emerge out of an agreement, will result into a contract. So it means any obligation which is not contractual in nature, or any agreement which is social in nature, or any agreement which or obligation which is not recognized by law will not be considered as a contract. So this particular slide is very important, and on this basis generally two question comes which are called as the statement questions, and in the exam the questions can come. The first statement is all contracts are agreements, but all agreements not necessarily be a contract. Discuss. So in this particular question, what we have to explain is that we have to explain meaning of contract. We have to explain meaning of agreement. We have to explain types of agreement, dividing into social and legal agreement, and then we have to explain the relationship of the contract and agreement. So four sections would be there: meaning of contract, meaning of agreement, types of agreement with the help of example, and the remarks, relationship between the two, and we can say the conclusion. So this way this particular question would be answered, and the similar question can be there, that is law of contract is not whole law of all obligations. Discuss. So this will again have the same concept, that we have to explain the term contract, we have to explain the term obligations as social obligation and legal obligation, and it is we have to understand that there is only those part of obligation which are legal obligation, which are recognized by law, it will result into the contract, and there can be other statement in terms of law of contract is of obligation which have its source from agreement. Its source from agreements. So this can be the other question. So there can be the straight question, can be what is the meaning of agreement, define contract, what are the essentials of enforceability by law. So straight questions definitely can be, explained. But when there comes the statement question, so we have to adopt the analytical approach to attempt these kind of questions. And for the same, it is expected at university level that you need to learn the analytical skills as well. So